there appears to be physical evidence that corroborates it. Even before the finding of the bloody items in the East Brunswick ShopRite garbage can, apparently there were bloody handprints that led up to Mr. Rosado's apartment that led the police to consider him a person of interest from the start. So there is more than just the statement, but it does appear that the statement itself was quite instrumental in establishing the incident and how it happened here. So with that, I will move forward. And since, as Mr. Clark noted, the presumption for detention in light of the nature of this charge puts the burden on defense counsel to demonstrate by a preponderance of the evidence that there are conditions that can assure community safety and the defendant's appearance, and they will not obstruct the process. So I will turn it over to Mr. Clark first, since the burden is yours.
Thank you, Your Honor. Your Honor, I did address already the informational factor that goes to weight of the evidence, which is one of the criteria I believe overcomes that rebuttable presumption. And if you look at the nature of the case itself, that's one of the factors that weighs in overcoming the rebuttable presumption. But I'll go through each one of the factors, Your Honor. And the first one is the nature and circumstances of the offense. And Your Honor can take this into account, considering whether we've overcome our burden. This isn't a case of stranger on stranger violence. So you don't have a history of Mr. Rosado being violent with anybody else. There is no prior criminal history at all. You don't have to worry about future acts of random violence. That's why I think the nature and circumstances of this offense weigh in favor of his release, Your Honor, because it's clearly an altercation between two people that have had an ongoing feud for about 3 years. And Mr. Rosado did everything possible to avoid that date. He was not moving out. He has reported to the police that this person had threatened to kill him before. And yet nothing had been done to alleviate the problem. And again, they've even talked to the victim's wife, Miss Thomas, and she indicated that she knew there was a problem between her husband and my client, that he had a real problem with his neighbor. Also confirmed by the landlord, Mr. Ferrer. He said these guys had complained repeatedly to him about each other making too much noise. And part of the problem, I think, Your Honor, there's a very thin wall between the two of them, between Mr. Thomas's office and Mr. Rosado's apartment. So again, it's not circumstances that are likely to repeat themselves, and it's not like Mr. Rosado has had problems with anybody else. And again, you know, he did indicate, and it will be borne out at trial, I suppose, that he was acting in self-defense. I've already gone through the weight of the evidence, Your Honor. I won't do that again. It's based primarily on all the things I read earlier about the statements made by Mr. Rosado. I will say, from his statements, he did not intend to kill anybody on that day. Now, to go through the history and characteristics of the defendant, including the defendant's character, that's the first one. I have limited information at this point, Your Honor, but I did provide a statement from his mother, Jillian Lopez, and his uncle, Elliot Ramos. He's a hardworking, quiet young man, stays to himself, avoids drugs and alcohol. He's never had any legal problems or trouble. That's his character. His family ties. He has an uncle, Elliot Ramos, who's 52 years old, lives in New Brunswick at 192 French Street. He's an Air Force veteran, supervisor for security company, and he was willing to be Mr. Rosado's custodian. And that was one of the things I could ask Your Honor to consider as a condition if you release him, is to appoint a custodian. Mr. Ramos is willing to do that. He has a grandmother on Sidham Street, New Brunswick. He has an aunt in North Brunswick. Although his mother and stepfather are very involved in his life, they are from Florida. So that's not the tie he has to this community, but all his family members are here. As far as employment, Your Honor, another factor, Your Honor, consider that overcoming the rebuttable presumption. He works at Lowe's in East Brunswick for over a year. He works the overnight shift, 8 p.m. to 6 a.m. According to Mr. Rosado's mother, she spoke to the HR department, who spoke very highly of him at Lowe's. Before that, he was at TJ Maxx for a year. Before that, he was at AutoZone for 5 years. So Mr. Rosado has always kept himself gainfully employed. One of the other factors, Your Honor, is financial resources, and I'm never sure how that factor plays good or bad for anybody. If he has tons of financial resources, I guess the fear is he might take off and could get himself out of town. However, his financial resources are somewhat limited. He's made money, but he just makes enough to pay his rent and use public transportation to get to work. He doesn't have a car, a driver's license, or a passport. All factors that
Or a
weigh
what?
a passport,
Okay.
a driver's license, no car, no passport, does not have the financial means or even the ability to flee the jurisdiction. Now, as far as length of residence in the community and community ties, I already mentioned his family members. He was born and raised in New Brunswick, born at Robert Wood Johnson Hospital in 1986. He's lived at his current address where this incident occurred, Your Honor, for 13 years. Before that, he lived on Somerset in New Brunswick with his mother for 2 years. His whole 34-year lives have been spent in New Brunswick. It's the only community he's ever known. And I've already mentioned he doesn't have any access to a car or driver's license. Now, past conduct, history relating to drug or alcohol abuse, criminal history, and record concerning appearance at court proceedings. I think these all factors all go together. I lump them together because they're related. But as I said, he's 34 years old and no prior criminal history or past conduct, adult or juvenile. So there would be no record concerning court appearances, obviously. Again, this is according to his mother. He's not involved with anything like drugs or alcohol. The fourth factor, whether at the time of the current offense or arrest, the defendant was on probation, parole, or on other release pending trial. Well, I already told you that, Your Honor. There's nothing. He's never been in contact with the police or arrested. He's not pending trial in any cases. Now, the nature and seriousness of the danger to any other person or the community that would be posed by the defendant's release. I've already mentioned this, but again, it's back to this is an isolated incident between two people having a long-standing problem. This is not a random act of violence where you have to fear Mr. Rosado is in danger to anybody else in the community. In fact, nothing blew up in this case until 3 years. So obviously it was building between the two of them. As he said, he acted in self-defense. It was not his intention. There's no indication he has problems with anyone else. He'd been living a quiet and isolated life. He seemed to work hard. The circumstances don't suggest he would pose a danger to anyone else if released. Now, the nature and seriousness of the risk of obstructing or attempting to obstruct the criminal justice process, it doesn't seem he could possibly do that if released, Your Honor, because there's nothing else for him to do. The evidence has been gathered. The DNA was gathered already. The scene was processed. He told them where to find the evidence. So it's not like he can hide it now. It's not an identity case where he could potentially obstruct by concealing the identity of someone else. He's already said it was him and Mr. Sagun involved in this. So I don't see how his release could pose a danger to obstructing the criminal justice process. I know the release recommendation, the pretrial services program, which is the last factor, they use the risk assessment. And I know based on the nature of the offense, they specifically don't recommend release. However, as Your Honor can see from the PSA, Mr. Rosado scores a 1-1. So he's the lowest on the risk scale for failure to appear, and he's lowest on the risk scale for new criminal activity. So for all those reasons, Your Honor, the defense has overcome the rebuttable presumption. There is a preponderance of the evidence when you look at all those factors and look at Mr. Rosado and his history and the fact this was an isolated incident between these two people. It all favors in overcoming the rebuttable presumption and allowing him to be released. And again, as an extra overlay, Your Honor, there are many circumstances or other things Your Honor can do in releasing him to give an overlay or an extra layer of protection for any concerns there might be. I know you can put him on house arrest, Your Honor. You could commit him to his uncle is willing to be his custodian. He could be on the electronic monitoring device. So there's no possibility of him fleeing or going anywhere else. You could impose a curfew. You could just let him go to work and come back home. All these different factors, I think, weighs in favor of certain conditions that can be fashioned here that would protect the community, make sure he appears in court, and make sure there's no obstruction of the criminal justice process. So for all those reasons, Your Honor, I'm asking that you release Mr. Rosado with the conditions that Your Honor feels are appropriate. Thank you very much.
Thank you, Mr. Clark. Mr. LaMountain?
Judge, with all due respect to counsel, I don't see how, based on the facts before you, that an argument can be made that the nature and circumstances of this case, the facts of this case, allow the rebuttable presumption to be overcome. It just plain common sense flies in the face of that, Judge. We have a defendant here who had the ability to go in and out of his residence through a back door that only he had access to, and a victim who had all his belongings and clearly was leaving for the day with his coffee mug and his car keys and his folio and all his belongings. In 23 years of prosecuting homicide cases, I've never seen somebody who's going to go out and confront somebody physically who brings all his other stuff with him, Judge. Okay? And then based on the defendant's own self-serving statement, the victim goes flying down to the base of the stairs. And this person who he has this hatred towards, who they've called the police on each other, who they've called the landlord on each other, his response is to go down the stairs and check on him. And when he goes down to check on him, he ends up punched in the face and stabbed 53 times, Judge. I'm just not sure how we get to the fact that the facts of this case are overcome based on the defendant's own self-serving statement, which is constantly contradicted by the evidence. There's a trail of blood up to his apartment, blood in his apartment, and then not only attempts to clean up the evidence, but he takes the bloody clothes and takes the knives and goes a town over to dump them. Meanwhile, the victim is still, according to him, when he left, gasping for breath and still alive at the base of the stairs. And we're going to find that this gentleman is not a danger to the community. We're going to find that these facts, the nature and circumstances of these facts overcome the presumption. I respectfully just don't see it, Judge. This defendant stabbed his neighbor because he didn't like him, because the neighbor was an accountant trying to do his business a month and a half away from tax season, and he wanted to play his music and didn't like the fact that his neighbor was trying to do his job done. So he stabbed him and he punched him and he threw him down the stairs. And he clearly is a danger to the community. His attempts to cover up the crime clearly present that he's a flight risk. And respectfully, the state asks that you hold Mr. Rosado pending his trial.
Thank you. This matter comes before the court on the state's motion to detain Mr. Rosado, and I've already made findings regarding probable cause, and in that finding addressed in part the weight of the evidence based upon the presentations of both counsel. And I do have the public safety assessment for guidance in this matter. And on that public safety assessment, Mr. Rosado scores 1, the lowest possible score on the risk scales for failure to appear and new criminal activity. There is no new violent criminal activity flag in this matter, which I found to be unusual considering the nature of the case, because very often when the public safety assessment is prepared based upon a violent crime, such as this one, the flag is automatic. But what is automatic here is no release recommended based upon the exposure that Mr. Rosado faces if he is convicted of first-degree murder, and that is life imprisonment. So as noted earlier, the burden of proof shifts to the defense to establish by a preponderance of the evidence that there are no conditions that will assure community safety, that he will not obstruct, and that he will appear in court. And I look at the various factors as noted by Mr. Clark, the nature of the offense. We do not get much more serious than a murder. I would note with regard to the description and the proffer by the state that defense counsel doesn't have an ME report at this point to reflect the 53 stab wounds, but I will accept the state's proffer with regard to that indication of the findings of the medical exam of this victim. This court, that denotes a particularly brutal murder or a brutal homicide. Now, to the extent that self-defense is going to be claimed here as bearing on the strength of the state's case for first-degree murder, that is something that I'm sure that counsel will pursue in the course of handling this case. But the brutal nature of this crime, I find, does weigh against that finding of self-defense. It's clear that both parties had issues with each other prior to this incident. That's undisputed. And police were involved based upon calls from both sides. But again, the self-defense claim is diminished because beyond the stairway, we have the act of then punching in the face and then 53 stab wounds to this to this victim, creates a problem for the defense here. Self-defense in some regards does require a reasonable duty to retreat. And that duty could have started at the top of the stairs if indeed, based upon the proffer of defense, it was the victim that was the aggressor at the top of the stairs. Whether he came down to the bottom of the stairs to try to render aid to the victim, that I suppose is a possibility, and the defendant would likely have to testify if he were to raise that issue at trial. But I come back to the 53 stab wounds after that. Even if it was the victim who pulled out the knife and started with the knife while he was laying on the ground after falling down the stairs, which does require some stretch of logic, the fact that he is able to get the knife in his own hand and then proceed to stab the victim that many times is alarming and concerning. As noted by counsel and as reflected in the public safety assessment, Mr. Rosado has no prior involvement in the criminal justice system. There are no convictions of any kind. And by all of the information that I have, he has led a law-abiding life. He works and he's had multiple jobs, which he appears to hold for a period of time. He's lived in that residence for 13 years, so he's got strong community ties, including his uncle who offered to house him, and that's Elliot Ramos. And based upon the letters that I've reviewed, it does appear that he's got good character in light of his lack of a criminal history and his work history, but that come to a halt as a result of these incidents. Now, State versus Mercedes instructs the court not to detain someone based upon the serious nature of the charge alone. And in this case, I do believe that we have a bit more than the serious nature of the charge. We have what I consider to be an especially brutal act or acts committed by Mr. Rosado based upon the extensive number of stab wounds suffered by this victim. And the strength of the state's case is I believe it is high because there are certain inconsistencies that lead to some holes in the self-defense claim. And there is physical evidence that corroborates the defendant's statement, even though there are points of his statement that may be inconsistent. We know that there's motive based upon the prior issues that they have had that have risen to the level of requesting police to assist them at the scene. So we have more than just a serious case. We have a serious case with strong proofs, and the serious case is an especially brutal one. And by the nature of the especially brutal crime that was committed here, I believe it rises above the State versus Mercedes standard. So I do find that there is a danger to the community in light of the serious nature of this crime and the brutal nature within which it was committed. And the defense has not overcome the presumption to detain Mr. Rosado. I will tell you that when I am on, I considered all of the very positive arguments that Mr. Clark made on behalf of Mr. Rosado in an effort to do the right thing here. But applying the burden, if I am not convinced by a preponderance of the evidence that there are conditions that will assure community safety and the other elements that the court has to consider, then the defense does not prevail when the burden is on the defense. So despite all of the very positive background that Mr. Rosado has, the brutal nature of this crime leads me to my decision. And so with that, I will advise you that you do have 1 week to appeal my decision. And this hearing is complete. Is there anything further?
Nothing, Judge. Thank you.
No, Your Honor. Thank you very much.
All right. Thank you. And to whom should I send my write-up for the preparation of the court order?
Hi, Judge. Good morning. You could send it to me, Alejandra from pretrial.
All right. Thank you, Alejandra.
Thank
All right.
you.